Ladies and gentlemen, may I ask you to take your seats? Good afternoon. We will continue now with the second session of this conference, marking the 20th anniversary of the entry into force of the Rome Statute of the International Criminal Court. This session will focus on the life cycle of an ICC case in the courtroom and beyond: trials, appeals, and reparations. Trials, appeals, and reparations. The panelists are Professor Raul Pangalanga, former judge of the ICC, Jennifer Nauri, who is the president of the Bar Association, Minu Tavares, who is the chair of the board of directors of the Trust Fund for Victims, Peter Lewis, the ICC registrar, and Professor Carla Firstman of the University of Essex. And the chair of this panel is Lorraine Smith Van Lien, an international human rights lawyer and dedicated advocate for the rights of victims and women. She is the founder and executive director of Talawa Justice for Women, a non-profit organization dedicated to connecting, equipping, and amplifying the voices of women grassroots leaders from the Global South. She also works as an independent international human rights consultant with a specific focus on victims' rights. She has previously served in several organizations and is one of the patrons of the Enforcement of the Right to Peace Global Advocacy Program. Lorraine, all yours.
Excellencies, Your Honors, distinguished guests, online and in the room, colleagues and friends, it is a privilege to welcome you to the second panel discussion entitled Lifecycle of an ICC Case in the Courtroom and Beyond: Trials, Appeals, and Reparations. I traveled in this morning for this event, and as I listened to my colleague Angela as she opened the session. I listened to the distinguished panelists this morning, and I thought back to my early days in 2008 when I came to The Hague as director of the International Bar Association ICC program. I remembered how I stood waiting to see Thomas Lubanga Diallo, the first ICC accused person to appear before the court. And I cannot imagine that I'm standing here now and that the ICC is 20. The ICC is no longer a puber. I remember when we were in Uganda at the review conference, and we said the ICC was still a baby, still very young. The ICC is 20, and I ask myself, where was I at 20? What did I do at 20? Just out of puberty, but not quite an adult. This afternoon session will explore what it means to be an adult, or to be on the threshold of adulthood. A court that has tremendous meaning for victims, but which is still a court that is required to ensure fair trials, a court that requires cooperation of states in order to function effectively. What does it mean to be a young adult? The International Criminal Court, I would dare say, has truly come of age. It has weathered its fair share of criticism, direct challenges, and trials. Indeed, the Lubanga case that I mentioned was a test for the court in those early days. Plagued with teething challenges, the court was forced to confront a number of difficult issues, including finding that delicate balance between the fair trial rights of accused persons and the rights of victims. It is interesting to me because in those early days, I remember advocating for a defense bar, an international criminal court bar, and it is such a pleasure to see that one exists today. I think of where the ICC is, and I recall the words of the prosecutor this morning, and indeed the words of the moderator in the first panel. She alluded to the yellow Nokia phone. The prosecutor said, yes, indeed, we may have looked at a yellow Nokia phone, but we are moving in a new direction because the ICC is in a brand new world. What is clear to me is that the ICC is part of a growing ecosystem. And that is what this panel will attempt to unpack today. An ecosystem that has to balance the interests of defendants who come before the court. An ecosystem that includes victims and affected communities and those who look to the court for hope and for justice. The question is that working for victims? We will hear from Professor Firstman, who will tell us what that means and what the ICC has meant for victims. An ecosystem that demands cooperation and collaboration with states. An ecosystem that requires resources in order to function effectively. The registrar will tell us in his presentation about the importance of cooperation and why this court simply cannot function without it. And what of reparations? At this juncture, when I was standing at the threshold looking at the Lubanga case, the question of reparations had not even come up. Today, the ICC is facing several cases and situations where the question of reparations and/or assistance is an important issue. We will hear from the chair of the board of the Trust Fund for Victims on the issue of reparations. And last but certainly by no means least, we will begin this discussion by talking about the complexity of the ecosystem that the ICC is, the mixture of common law and civil law, and how judges have had to navigate that complex issue. With that, we have former ICC judge, now Professor Pangalanga. Ladies and gentlemen, I have deliberately decided to make my remarks brief because we are already seeing a number of questions come in on the issues that will be discussed in our panel today. So without further ado, I will introduce our first speaker, Professor, former Judge Raul Pangalanga. He is a well-known leading academic, former ICC judge from 2015 to 2021. He currently teaches law at the University of the Philippines, where he has previously served as law dean. He has also taught at the Hague Academy of International Law and at the Harvard Law School, where he received his LLM. Professor Pangalanga was a Philippine delegate in the drafting of the Rome Statute in 1998, and he co-chaired the national campaign for ratification of the statute by the Philippines. He will address us on how to provide justice in a mixed legal system. Judge Pangalanga, the floor is yours.
Thank you so much, Lorraine, for that very kind introduction. I'd like to thank the President of the Court for inviting me to speak today and congratulate him and the rest of his colleagues for this big event in the life of the Court. When we speak of mixed systems, of course, we refer to the big traditions, the common law tradition and the civil law tradition. And this dilemma is nothing new to the ICC. We confronted this all the way back to Nuremberg. If you recall, it was the decisions at Nuremberg were rendered by a bench of professionally trained judges, not by a jury, but at the same time, the procedure that they followed was modeled after an adversarial system, where each side, the prosecution and the defense, each had their turn at presenting their evidence. In my case, personally, I encountered this debate very early on in my work at the court. I was assigned to my first case. I asked for the charges. And so I looked for the indictment. And I was told, Judge, over here, the document you're looking for is called the DCC. And I like, where is this coming from? It means document containing the charges, the most neutral term to refer to that document, because it is literally just lifted from what I think is basically a side provision in the Rome Statute. At first, I took it as some sort of a ceasefire in the big debate. In other words, just choose the most neutral sounding term. But later on, I realized there were actually deeper issues involved, dealing with, first of all, the role of the prosecutor in crafting the charges to be considered during the trial, and conversely, the nature of the document itself of the charges that the accused is supposed to defend against. It also goes into the content of the document. Is it supposed to include, to cover just the facts and the evidence? Or is it supposed to deal with more detailed evidence that the prosecutor intends to rely upon in the course of the trial? And finally, it goes into the question of the right of access to the information contained in the document, at what point it arises, and the disclosure duties of the prosecution. I would encounter this dilemma every now and then in procedural and terminological nuances. For instance, terms that I took as so natural in a trial: direct examination, cross, redirect, and recross. And apparently, in the culture of the court, they preferred the term just examination, without the qualifiers. Also, I would encounter the term a witness for the court, and I was quite perplexed because I know that witnesses are called by a party. There is a calling party, and that therefore the witness is supposed to testify for one side or the other. And of course, the civil law approach is that the witness testifies for the truth, which is the goal of the trial. On the other hand, there is also the very sharp rules making a distinction between witness manipulation and witness familiarization. And we have Article 70 rules, which basically insulate the witnesses from counsel and, of course, from the parties. But before I proceed to my analysis and recommendations, let me just identify the big-ticket issues in this field. The first is characterization of crimes. The common law would empower the prosecutor to craft the charges that the prosecutor is prepared to litigate. The logic being their risk, their call. The civil law judges, of course, are aghast. They will recoil at the notion that the trial is merely a contest among lawyers on who's better, and affirm that, again, the goal of the trial is to establish the legal truth. Not the partisan truth as seen as one side or by the other, but the truth that the court will rely upon when it makes a determination of guilt or innocence. And thus, eventually, we have the Regulation 55 principle that allows the judges to recharacterize the charges. The second is the questions relating to a plea of guilt, and in relation to that, plea bargaining. the common law, in the common law, the plea, the admission of guilt is not just evidentiary, it goes into the plea. Evidence is meant to prove what is there in the pleas. In this case, the guilt is established in the plea itself. And for the common law, therefore, the only question confronted with the plea of guilt is to ascertain that the plea is free and knowing. I won't go into the detail of free and knowing consent. But contrast that to the civil law approaches to the plea of guilt, which says that that is merely a subjective truth and that the goal of the trial is the objective truth, the legal truth, that must be established by evidence independent of the plea of guilt by the accused, which, by the way, is the rule codified in the Rome Statute. The next and the last of my examples is the most recent, and I would say the biggest of all these skirmishes on this issue. No case to answer. It has been affirmed, it has been rendered by the court in the Kenya cases, Ruto and Sang, and more lately in the Bagbo Blegode case. It's been affirmed both times by the appeals chamber. But it has no express authority, no express provision in the Rome Statute. It is implied by the catch-all powers of the trial chamber or the fair trial guarantees in the statute. There is even an issue of whether a decision rendered upon a no case to answer a motion is a decision that satisfies the requirements of Article 74. But it has been affirmed soundly by the appeals chamber itself as satisfying the Rome Statute's standard for evidence sufficient to prove the accused guilty beyond reasonable doubt, satisfying the presumption of innocence, and that therefore, if after the prosecution's turn to present its evidence, there is not enough evidence to establish the crimes charged, then even at that stage, the trial chamber was entitled to hear and to grant a no case to answer motion, which in the common law tradition will be referred to as the demurrer to the evidence. Let me now take a few steps back. The debate, former President Philippe Kirsch mentioned this morning that the debate was rather intense early on in the life of the court. I would like to say that the debate at this stage is a matter no longer as a clash between two systems, that the judges, as I will discuss later, have confronted it simply as a search for the best practices, the best ways by which to deal with issues, the best way by which to carry out, to discharge the obligations of the court under the Rome Statute. So in my remaining time, let me just do a quick review. First of all, dealing now with these issues in a sober and common sense way, and which, by the way, I see the turning point as happening under the presidency of Sylvia Fernandez. I don't know if Sylvia is here. The shift toward a common sense approach to these issues. It still presents challenges. The first, when you mix and match civil law and common law concepts, there is the difficulty that many of these concepts evolved within the structure, within the milieu of a system. So, for instance, a no case to answer motion assumes that there is a sequence in the presentation of evidence which we identify with the adversarial system. There is also a difficulty which arises from the fact that in some chambers, the vetting of the evidence, the determination of admissibility of evidence is deferred toward the end of the trial, such that if At that stage, after the presentation of evidence of the prosecution, the court is poised to render a decision. The prosecution is not advised which of its evidence is in. Of course, a court can still say that based on our view of this entire mass of evidence, it still fails to meet the evidentiary threshold under the Rome Statute. But notice, had it been a civil law court minded, where the judges are minded to be more involved in the presentation of evidence, then perhaps before the demur to the evidence is granted, then the judge could have told the prosecution what was wanting in its presentation. The same thing with a range of prosecutorial discretion. A plea of guilt must be seen not as a question of civil law versus common law, but rather seen in the context of the Rome Statute and of the function of the ICC, dealing with the most serious crimes of concern to humanity as a whole. And thus the prosecutor should be allowed enough leeway to deal with the resource constraints, with the political constraints, given that the court is faced with various pressures, competing pressures to deal, such that it is damned if it does, damned if it doesn't. And that function of quality control, that filtering mechanism, is best performed at the level of the prosecutor. By way of closing, the court is both a creature of law and a creature of history. And as noted earlier by Professor Robinson, this leads to contradictory demands upon the court. And for me, the value of this debate is that the civil law and the common law interface within the framework of the Rome Statute will give us a way to address both needs of the court facing the demands of law and facing the demands of history. Thank you.
Thank you very much. Thank you very much, Judge Pangalanga. Lots of food for thought there. I'm sure Jennifer might be tempted to respond, but I will introduce Jennifer Naouri of France. She is president of the International Criminal Court Bar Association, which is the professional association of counsel for the defense and for victims at the International Criminal Court. Jennifer has acted both as defense counsel and a legal representative for the victims in complex international cases involving genocide, crimes against humanity, war crimes, and sexual violence. She is currently lead counsel for Mohammed Saeed at the ICC. And Jennifer will address the issue of defense perspective on the fairness of trials at the ICC. The floor is yours.
Thank you, Lorraine. Je parlerai français.
I will speak French today, and I think that is important to underscore it, that the ICC was created with two working languages that had to be equal. Today, we need to recall that French is one of those working languages. It is a singular honor for me to share with you today some realities of the ICC from the point of view of the defense. The rights of the defense are the foundation of all democratic judicial systems. So any jurisdiction that gives the place that it deserves to the defense and all the resources makes it possible to administer fair justice. The ICC, when created, had a promise, exemplary and fair justice that would be recognized by all affected populations and litigants. Justice that could inspire all jurisdiction across the world. I'm one of that generation that has witnessed this from the university to the creation of this criminal law and devoted all their lives to it. 20 years later, did the ICC uphold its promise. The cases before the ICC really and intrinsically fair? I have been in the defense. There is a defense office, and that office was in the offices of the premises of the ICC. It is great progress, but there is a bar that gives advice. I would never have dreamed of it. A bar that gives advice to defense teams. I think it is very important for all counsel that should participate in that justice. So if they are not parties to the trials, there is no fair justice. Now, the balance sheet, are there fair trials? Now, you have adversarial trials, according to which the prosecution has the onus to demonstrate the guilt of the accused beyond all reasonable doubt. It is also important for the ICC to ensure that the defense has all the resources necessary to challenge the prosecution evidence. Madam Chair, there is also the issue of the admission of evidence and the assessment of evidence, which is at the heart of the ICC. To ensure this, the defense must have the necessary tools to analyze that evidence and to dispute it, including the possibility of carrying out investigations, the confirmation of charges that should ensure that only crimes with grounds are referred to their trials, and the defense should be given the time to analyze the evidence. Now, 20 years later, there has been expeditiousness of trials or proceedings. Now, is this at the detriment of the defense? The answer is nuanced. Expeditiousness of trials is important, and it is also important not to have pointlessly long trials, but it should not be done at the detriment of the accused persons. For example, the accused person must not waive a right. For example, a confirmation of charges, proceedings, because of expeditiousness. It has to be necessary not to go too fast and to prevent adversarial proceedings. So the defense must have the time and necessary means to contradict the prosecution. The second principle is orality and publicity of proceedings. It is necessary to discuss the fundamental role of the defense for the ascertainment of the truth in the courtroom. So the departure point of ICC was public trials, almost broadcast live, so that all the litigants and the communities affected could claim ownership. They should give the means to witnesses, courageous people, all parties and litigants, that they should share their experiences with all the entire world. Now there is a hybrid system of civil and common law, and there is the manner of questioning which should avoid re-traumatization of victims, and we try to take into account the different cultures of people. That is important. Today, because of expeditiousness, there are many trials also based on testimonies. Rule 68 makes it possible to admit prior written statements in lieu of testimonies. This is more and more used. So these statements are not totally public, and so the substance is sometimes hidden. Sometimes not hearing the witness is not only a violation of the principle of orality and publicity, but also prevents the parties, including the defense, to test the evidence. So the balance sheet is that we should not overuse that rule, Article 68, so as not to deprive a fundamental right of the witness, that is to really examine the witness and authenticate the evidence. This third principle is the equality of arms, and this means perfect equality between the prosecution and the defense, because the prosecution has to take care of many cases, which is not the case with the defense. But the defense must be able to accomplish its mission without having additional burdens. Today, the reform of the legal aid is still ongoing. And so the equality of arms is today undermined, first of all, because of the resources given to the defense teams. So the defense teams do not have the same or similar work or salary conditions as the OTP. The means to investigate are not comparable. The equality of arms presupposes an equality of treatment between the members of the defense and the members of the OTP, but also an equality of the working conditions between the prosecution and the defense. So the conditions, they work in the same conditions on a daily basis. They accomplish their missions in the same way, but it is not possible to do that when you do not have enough resources, when you do not have enough rest or enough social benefits such as compassionate or sick leave. So there should be a strategy to improve the culture of work in the court, given that there should also be equality of genders. The majority of the members of defense teams are women. There is another principle which was talked about yesterday, or rather this morning, the presumption of innocence. And so in that case, freedom is the rule and detention is the exception. So the ad hoc jurisdictions, for example, made the freedom of the accused the rule. That is the opposite. In spite of despite everything, detention seems to be the rule. In no case except for one was provisional release granted. And the chamber for Kosovo, for example, provided for such circumstances in case, but the ICC decided that even after acquittal, detention can be justified. So we have to reflect on the amendment of the statute so that the true rule should be implemented. provisional freedom should become a reality, especially since justice is rendered far away from the communities and families concerned. And family visits are practically inexistent these days. So to conclude, from the point of view of the rights of the defense, the ICC and the statute provided for many tools for the defense, but the practice has revealed that the defense does not have all the tools. You have acquittals and other decisions that have shown that the judges administer justice, but the court can adapt itself to each of the cases. And this must involve the prosecutor, the judges, the defense, because we are in the same boat, the boat of international criminal law, and each person must work towards the guidance of the boat for the administration of justice for all the communities involved. And it is in that manner that we can achieve the promise made 20 years ago, that of fair justice. Thank you.
Thank you very much, Jennifer, and for that reminder that indeed it is one boat, as I mentioned in my opening remarks, one ecosystem. As part of that continuing discussion about being in one boat, we are now going to move to the issue of reparations. And allow me to introduce the chair of the Board of Directors of the Trust Fund for Victims of the ICC, Ms. Minou Tavares Mirabal. She is from the Dominican Republic. She's widely renowned for her long-standing work for democracy, justice, the defense of human rights, the fight for equality and non-discrimination. She led the involvement of the Dominican Republic at the Rome Conference of 1998, and her legislative initiatives and political mobilization were key to securing the country's ratification of the Rome Statute in 2005. Ms. Mirabal will address the issue of reparations, a critical aspect of justice at the ICC. The floor is yours.
Thank you, Chair. Your Excellencies, thank you for the opportunity to address the participants of this important commemoration. As some of you may know, my mother, two of my aunts, my father, and thousands of men and women of 3 generations were assassinated in the Dominican Republic under the orders of the dictator Rafael Trujillo and of those who governed after him. These were crimes against humanity. This tragedy, which marked my life and my country, has committed me to work for future generations to ensure that the rule of law governs our lives as civilization. I have sought to undertake my fight with stubborn optimism, a term used very often by a dear friend of many of us, the late Felipe Michelini, former chairperson of the board of directors of the Trust Fund for Victims. I use it today because it is a shared characteristic of the many of the people I have walked and worked with in the context of human rights. In my country, which gave the Rome Statute its 99th ratification, as in many of the 123 where I was able to witness from close the efforts for ratification, it was an optimistic stubbornness from victims and activists what drove discussions across party lines to define how we wanted the future of our countries and the world to look like. It is simple. One governed by the rule of law, one of never again. Nunca jamás. It is thus important to recall that while the diplomats and lawyers drafted the statute, the ink of their pens is made of the dreams and pain and optimism and stubbornness of victims. For these reasons, it is an honor and an obligation for me to speak today with these victims in mind. The victims of the past, those whose optimistic stubbornness drove the international community to ensure the adoption of the Rome Statute. These include countless of World War II and Holocaust survivors from Eastern and Western Europe, including Madame Simone Veil, the first chairperson of the Trust Fund, and other victims from all regions of the world. It is an honor to speak of the victims of the not-so-distant past, those who have suffered even after the Rome Statute was adopted in each and every country that is today a situation before the court. We must speak of the victims in each and every country that should be a situation before the court, but that it is not yet recognized as such. And to speak of the victims of the future, a certainly tragic one, as growing corners of our world are turning increasingly armed, unequal, and authoritarian. When the parliaments of the world, those elected by the people, ratified the Rome Statute, they accepted, applauded, and welcomed every single and complex dimension of this founding document. They accepted the 4 core crimes, including the crime of aggression. They committed to support the independence of the prosecutor and of the judges. They applauded victim participation, and they welcomed the establishment of the Trust Fund for Victims, which I am honored to chair since December 2021. It was always and remains upon us international bureaucrats to make those defining features of the Rome Statute a reality, to set up the court. Many challenges and impossibilities have been overcome: securing cooperation, upholding the principle of no immunity, defining the crime of aggression, protecting witnesses. These issues are as political, financial, and operational complex as the goals of victim participation and victim reparations. This complexity is even more considering that victims are hundreds, thousands, and the convicted are indigent. There is therefore no space for compromise or abandonment. Victim participation and victims' reparations are rights and are essential features of the Rome Statute. They cannot be questioned, brushed over, or neglected. It is our responsibility, all of those here joining in this celebration, to see that reparations are realized. What are we doing to date? Since its first order of reparations issued in 2012 and amended on appeal in 2015, The court has awarded reparations to victims in each and all of the 4 convictions. In all 4 cases, the ICC ordered reparations through the trust fund. A 5th case is in the pipeline as judicial reparation proceedings have been conducted while the conviction is still under appeal. In order of value, the convicted persons were respectively ordered to award reparations of US 1 million in Katanga, euros 2.7 million in Almaty, US dollars 10 million in Lubanga, and US dollars 30 million in Taganda. The programs implementing reparations in the case of Katanga and the implementation of individual and symbolic awards in Almaty are approaching an end, while the implementation of collective reparations in Lubanga and Almaty started in 2021 on the basis of multi-annual programs with constantly increasing numbers of victims who receive reparations. To date, there are around 900 beneficiaries in Ituri province and the DRC, and around 800 beneficiaries in Mali who receive compensations or rehabilitation measures, either through 7 implementing partners or the trust fund itself. Also, in line with this existing mandate, the trust fund implements since 2008 the programs in Uganda and DRC, and since 2020 in the Central African Republic and Cote d'Ivoire. In 2021 alone, these programs have benefited about 17,000 victims. Those TFB's programs have laid the ground for court-ordered reparations programs and may achieve among victims and support to the work of the ICC, even in situations where accused persons were acquitted or arrest cannot easily be achieved. There's so much to be done. There is, as we can see, important progress, but it is certainly not enough. The board of directors is seized and active in addressing the challenges, and we need help. First, there is the issue of needs. Reparations orders to date have a value of nearly 38 million euros, yet the trust fund received from fines, proceeds from forfeiture or reparation payments to date only 330,000 euros. Reparations are, therefore, being funded through voluntary contributions by states parties. To date, thanks to these contributions, the trust fund has been able to fully complement the payments of reparations in Katanga and nearly fully in Almaty, but this is a funding gap. The trust fund belongs to all states parties, and all contribute to the staff and core operations of the trust fund through their assessed contributions to the court. For its programs, however, the Trust Fund Secretariat has been able to raise only an average of 2.5 million euros per year in the past 15 years, an amount that is close to the cost of running Secretariat. This situation must be addressed with urgency, and the board of directors has taken it as central to our revitalization strategy. The priority for the trust fund is and will remain raise considerable more funds. Private donors must be pursued and will be pursued as a matter of priority for the board. But the fund will need to continue considering donations by states parties. Only 48 of 123 states parties, as I said, have contributed to the trust fund. Only 14 of them have contributed more than 10 times in 18 years. Contributions need to come from all states parties more regularly, and they need to be in higher amounts to match both the needs and the value and commitment of the Assembly and its states parties to victim rights. One of the biggest criticisms made to the Trust Fund has been the time it has taken to initiate programs of assistance and programs of reparations. This criticism is granted. There are at least two sides of explanation. One is the need to develop operational pathways for the fund to engage with victims, conduct procurement and due diligence requirements, administration and payments, evaluations, financial control, all of these required by the multiple donors. The other side is the obvious learning curve in setting up an entity like the fund. 20 years in there is still so much to do. First, the Trust Fund must enhance its participatory, community-driven, inclusive, holistic, creative, and structured implementation of modalities for reparations and assistance. The Trust Fund must also deliver reparations as efficient as possible administratively, meaning lowering its administrative costs and ensuring that most of every euro reaches the victims. Rehabilitation remains central, but so are other forms of reparation. Secondly, the Trust Fund needs to work conceptually, programmatically, operationally, as integrated with the court as possible. And finally, the fund must do better in communicating progress and results. The fund also needs states, parties, and civil society to be engaged and involved, to ask questions, to compel us to resolve. The IER has made clear findings. The new board of directors has committed to take specific actions to address the findings and to enable the Trust Fund to be in a position to face the challenges ahead. More situations with more cases and greater victims populations. 5 years ago today, on the occasion of the passing of Madame Simone Veil yesterday, Felipe Michelini offered a reflection that remains valid today. He said, there is so much to do. To continue working on the three pillars: prevention, repression, and reparation is an ethical, legal, and political imperative of the international community as a whole. We made the court a reality. Now, we will ensure with stubborn optimism and with the help of the court, the states, parties, and civil society to fully and broadly realize the right to reparations as enshrined in the Rome Statute. Muchas gracias. Muchas veces.
Thank you very much, Mrs. Tavares Mirabal, for this excellent presentation and reminder of the importance of and centrality of victims and the importance of reparations. But I have to say that I would like to just pause also to acknowledge two stalwarts who you have mentioned in your presentation. And I honestly am just hearing about the passing of Madame Simone Veil. Yesterday you said it was?
No. Yesterday was the anniversary.
Oh, the anniversary. I thought I had missed something. No, that was some time ago. But when you mentioned that in your presentation and you paid homage also to Felipe, I think it's also really critical that we remember those who have been with us on this journey and who have worked so hard to ensure that victims' rights are respected, and indeed for reparations. So I would like to just continue on that theme by inviting Professor Carla Firstman to take the floor. Professor Carla Firstman of the University of Essex. I think those of us in these circles know her as, for many, many years, the former director of Redress, an NGO that specializes in combating torture. She currently is the professor at the University of Essex, specializing in human rights, international criminal law, and public international law. Ms. Firstman, or Professor Firstman, has also worked for the UN High Commissioner for Human Rights in Rwanda, Amnesty International, and the Commission for Real Property Claims of Refugees and Displaced Persons in Bosnia and Herzegovina. You will notice that Professor Firstman should have been the last speaker, but we want to continue that theme of victims, so I invite you to take the floor now.
Thank you so much. It's such a great pleasure to be here, and also very, very fun for me because it's been about 4 or 5 years since my last trip to The Hague, what used to be a very frequent occurrence because of COVID and other changes. It's been some time since I've been here. It's a great honor for me to be here to address this audience and to participate in this 20th anniversary event. I've been thinking a lot about what I could say about the topic I've been assigned. Is the ICC succeeding in providing justice to victims? The first thought I had was, well, what is justice to victims? Is it about striking the right balance between victim and defense rights? Is it acknowledging that behind each investigation, each case, each proceeding, there are people, individuals of all genders, communities, young people, old people, who've suffered unimaginable atrocities? Is the act of acknowledging this fact enough? Should justice to victims be real? Should it be tangible, practical? Or are we really speaking philosophically or symbolically? Who should really be answering the question whether the ICC is succeeding in providing justice to victims? Perhaps it's a failure that it's me sitting here speaking about whether and how much justice for victims has been realized at the ICC. Sure, certainly, this is an issue I have championed for many years, and I have many views about it, but perhaps success, 20 years after the ICC has been established, with the key texts all recognizing the importance of victim participation and of fostering the dignity and inclusion of victims in matters that affect them. Success would have been the recognition that there are clear interlocutors from within the communities that have suffered most who could properly canvass the issues around whether the ICC is succeeding in providing justice to victims. Is providing justice to victims even possible? Given the nature and the scale of the crimes, is justice to victims a realistic benchmark? Full justice, justice that properly and fully responds to all the different kinds of harms suffered, may indeed not be a realistic proposition, but our role, or indeed the court's role, is to get as close as possible to full justice as possible. So anything less than the possibility of realizing full justice does not give us the license to say, well, okay, we can't do the full thing, so anything should go. We'll just choose amongst the toolbox of options and make it symbolic and give some appearance of justice. No, that will not do, not at all, even though symbols are certainly still important. So really the question when thinking about justice for victims is, what are we aiming for?
In my mind, justice for victims requires realizing victims' rights, being part of the process that leads to victims' empowerment and gives space to victims' unfiltered voices. We should be recognizing that for justice for victims to happen, we, those involved in the International Justice Project, whether inside or outside of the courts, we need to make space for victims, and we need to be prepared to be transformed by the act of giving space to victims. We've got to stop thinking that we've achieved something when victims finally understand the court's limitations and the boxes that they need to fit into and the hoops that they need to jump through to engage with the court. Also, we've got to stop thinking we've achieved anything meaningful when we take decisions on their behalf because we think somehow we know better what their needs are, what their priorities are, and what risks they face by engaging with the court. We must realize that it is us that need to evolve, not the victims. We also need to become more accountable to victims for the steps we take or do not take, and for how long it takes us to take any steps at all. This just means that there's got to be more latitude, more room, more space to be truly inclusive, to not only ensure that victims understand and are informed about what is happening, but it's to allow the procedures to be informed and to transform, to adjust to victims' realities and to what they find meaningful, whether this is timeframes, whether it's application processes, protective measures, rights of audience, assistance, or reparations. This is not to say that none of this is not already happening or that these concerns are not known or acknowledged. The court, its organs, and the associated institutions, including the Trust Fund for Victims, are all in a very different place today than even a decade ago, though there's still room for progress. And the word or the phrase that the chair of the board of the directors of the Trust Fund just gave us, stubborn optimism, I think is I really like that phrase. I think it's a very good phrase. And I think I am stubbornly optimistic. I'll highlight just a few issues where I think there's room for perhaps some further progress. First, giving much greater space for victims and victims groups at the preliminary examination, situation, and pre-confirmation of charges phases. Victims have distinct interests in prosecutorial strategy, decisions to proceed, not to proceed, or to hold an investigation in limbo. Giving greater space for victims and victims groups during those phases does not reduce prosecutorial discretion, it simply increases the accountability for the exercise of that discretion. Practically, this means ensuring a modicum of legal representation during these early phases and creating more space for judges to hear from victims formally. Second, finding ways for victims to contribute their views and concerns in addition to the common legal representatives that express legal arguments in The Hague. Building in intensive field-based two-way engagements between victims and court officials, including judges, would make victim participation more tangible for many, and modern technology makes this possible. We're only limited by our own creativity. Third, reparations. Reparations are hugely important, but we know difficult to get right. The starting point is by centering victims' agency and empowerment, both with assistance projects and court-ordered reparations. This is fundamental, especially where the nature and scale of the crimes makes full reparation impossible. Recognizing victims' role in coming up with solutions on what would be most meaningful and most helpful is in and of itself reparative
as it recognizes voice, dignity, and it contributes to empowerment. And there's a need to recognize that not all victims will be the same, nor will they have the same needs or aspirations. The fact that there's large numbers of victims gives no license to ignore this reality of difference. There's also a need to get much better with identifying, seizing, and preserving the assets of potential perpetrators for the eventual purpose of reparations. While not all perpetrators will have assets, certainly some will, as can already be seen by some of the cases that have come before the courts. There's also a need to do much better with timelines and timeliness, and this is something which has already been spoken to. The time it takes to reach the reparations phase is already inordinate. The reparation phase itself should aim for greater efficiency in achieving reparative outcomes. If all of this is done, will it be possible to say that the ICC is succeeding in providing justice to victims? Perhaps we will need to indeed be getting closer to this, but let's bring in the victims themselves much more closely into this debate. Thank you.
Thank you very much, Professor Firstman. Very interesting, very interesting and thought-provoking presentation. Stubborn optimism. As I look in the direction of the registrar, our final speaker on this panel, I wonder as he speaks about the issue of cooperation, whether stubborn optimism will also be needed. Peter Lewis is the current registrar of the International Criminal Court. His 5-year term started in 2018. He previously had a long career in the Crown Prosecution Service of England and Wales, most recently as its chief executive. In the context of the creation of the ICC, Mr. Lewis was a UK delegate to the Preparatory Commission for the Rules of Procedure and Evidence in 1999 to 2000, and a member of the expert working group on the draft regulations of the ICC's Office of the Prosecutor. The registrar will speak to us on behind the scenes, the essential role of cooperation in an effective trial. Over to you, sir.
Thank you very much. Before I actually get into the main part of the talk, I just wanted to say this. Yesterday, I had the great privilege of meeting a group of representatives of victims and communities from Darfur in the court. It was a very emotional day, actually, because they were at the resumption and had been in court in the viewers' gallery watching the resumption of the Al Rahman trial. I don't know if we're making a difference, but I do know we're having an impact. It's an emotional experience for all of us who talked and met with them. But what was fascinating was the questions they asked of me, because what they wanted to know was what was happening behind the scenes. They'd witnessed the court, the theatre, they'd seen the judges, they'd seen the parties, but what they wanted to know was how it all worked. Very practical things. What's happening to Al Rahman? Where is he now? In what conditions is he kept? The witnesses, are you going to look after them? How do you do that? But fascinatingly, for this talk, they asked me a lot about cooperation, of all things, because what they wanted to know was how the system worked. The actual question was about, is Sudan cooperating with you? So this talk is about cooperation, and I want to take you, as I hope I did yesterday, behind the scenes of the importance of cooperation. The headline issue here is all we have achieved here in the court in the last 2 decades is utterly dependent on cooperation. That's the first message. The second message is, if you see where the court is now going, the scale of the cases, the fact that the cases are in new places, new continents, the fact that there are new threats means the challenges for cooperation are going to be greater than ever. Now, we all talk about cooperation and tell you how important it is to us. But so what I'll do is take you behind the scenes. So 3 simple examples. You hear that there's been an arrest. Somebody has appeared in the court. What's happening, obviously, what's happening in front of the scenes is a group of people from the registry accompanied by a member of the OTP will have flown from Rotterdam to a country far, far away. It had been in that plane full of people. There'll be some security people, armed security people. There'll be some of the lawyers from the registry, one of the liaison officers from the OTP. They'll spend 2 days in the country. There'll be a domestic legal process, and the person will be flown back. They always arrive in Rotterdam at midnight, and then are processed and end up for the first night in our detention center. That's what you see behind the scenes. Behind the scenes, in most cases, the suspect at large groups, a joint registry group, will have been watching somebody for a long, long time. And they'll have realized that the person has left their stronghold. They're traveling. And they'll work out they might be traveling to a country that's a state party. Now, you may think cooperation means you send a letter to the state party saying, please could you cooperate, please could you arrest this person. That's not how cooperation works. It simply doesn't happen that way. Each state, they may have an obligation to cooperate, but they don't have to, and they can always find an excuse. And some of those excuses are valid. This will have an impact on our bilateral relations. This will cause violence in our country. It's just too unsafe to do this. Do we need a potential almighty fallout? So what do we do in terms of cooperation? So probably a year in advance of the arrest, at least a year in advance of the arrest, we'll have sent out a mission to the country. In doing so, we'll have probably spoken to all the countries represented here who have an influence on the affairs of that country. We'll have certainly spoken to the EU, who, as you know, have a great aid program throughout the world. We'll have a mission there, and then we'll probably bring back the people from that country to The Hague, funded by the EU, who so generously funded us today. They fund most of our cooperation. We will have sorted out the security. In many places, the risks of an arrest operation are huge. And the UN, who we rely on so often, who of course will always try and cooperate with us. We have a great relationship with them, but they've got choices to make too. We'll have spent some time with the UN making sure that we can safely get somebody in and out. So the cooperation you see to get what appears to be a simple event into order is actually a year's worth of detailed cooperation. Without that cooperation, no arrest. No arrest, no trial. Witnesses. If you watch our cases, as you know, if you go to the gallery, the public gallery, you can't see our witnesses, they're underneath you. But if you watch it when it's live streamed, you will see our witnesses give evidence. Often, you will see there a pixelated image. We've distorted the image and we've distorted the voice. So the only voice you hear is of one of our interpreters. If we've distorted their image, that means they need protection. When that case is over, the witness and their family are not going home. They're probably not home already, because we've moved them already, but they're not going home. The witness and all of their family will now be relocated. Now, we always say to people, we have no police force, we have no territory, we have no army. What happens to that witness next? All dependent on cooperation. We'll have spent some time in advance trying to find a home for that witness and their family. That's all we're looking for, is somewhere where they can live a decent life and be safe. We haven't got enough countries to do that. Sadly, many of the witnesses and their families, we have to move regularly as we try and find a home for them. There are less than 30 countries who have signed relocation agreements with us, less than 30. For our most vulnerable witnesses, where there's an active threat against them, there are probably 4 or 5 countries who are willing to assist us. Without their cooperation, we can't call these witnesses. No cooperation, no witness, no trial, no end of impunity. It's all based on cooperation. Finally, in a smaller thing, and something with reparations, I think, I'm looking at Peter, I think, and Minu, that I think probably next week you'll put out a press release about a mission that's going to take place. The country we won't talk about because of security reasons. Many of the places, as you will know, where reparations are taking place, Minu's mentioned it, they are not post-conflict zones. They're conflict zones. Maybe a different version of the old conflict, it may be a new conflict, but they are conflict zones. Some of the missions that we've got, including the one that I think you'll read about, there'll be a lovely picture of people, I hope, talking about reparations. And I look at the judge because these are some of his reparations, actually, in which he made the order. But it will be a lovely picture with smiling people. There is a whole convoy of the UN armed to the teeth behind there. And the UN have to make the choice for that to happen. I can tell you where we're talking about, they have got lots of calls on their security people. And it's hugely dangerous. We only can do that because we've got cooperation from the UN. If the UN wasn't there, we couldn't do it. Now, that's now. But what about the future? Just think about some of the things I've said about the cooperation that's needed with the new situations. Are the UN there? If they're not, who could we look to? Have we got the networks in place? The intelligence sharing? Have we got enough cooperation agreements to help us with witness relocation? Well, I can tell you the answer to that is we haven't. And with the threats we've got now, I think we're going to have a new set of allies to help us manage those threats. So, I don't know what the answer is. I think it's dogged persistence. That's what we're about. We've found a way of making this work. We've got great people who understand cooperation and make these things happen every day, behind the scenes. But with the challenges ahead, they're going to have to work really, really hard and be creative and innovative, but also rely on all your help to make this a reality. Thank you.
Thank you, Registrar. Dogged persistence and stubborn optimism. I think those were the two important phrases from this panel. We are at the stage where the floor is now open for questions. And I will invite persons in the room. If you have a card, you can identify yourself. Those who were here this morning. Yes. I see a question from Monsieur Keita, Jean-Pierre Keita. Please feel free to just hold up your hand and I will acknowledge you. And for those listening online, please send in your questions and we will also call upon you at the appropriate time.
Good afternoon. Thank you, Mrs. Chair. Happy anniversary to everyone, because this is our day, not only the anniversary for those working like me inside the court. Bon anniversaire et bonne fête à tous. Bonne fête au Canada.
And we also wish all the best to Canada.
French, to try to balance a bit based on Article 50 of the Rome Statute with two working languages. Je vais switcher en français.
So thank you very much, Chair. And thank you for setting the points for this session. Well, I would say that this is a family get-together. It's a family celebration. We're here together as a family to celebrate 20 years of the ICC, but also to gather our forces to face ahead into the coming decades. And to do that, it's important to look back and consider, well, what has not gone so well, what has gone well, and how we need to change and evolve. Now, I'm a pretty stubborn type, but I'm a stubborn optimist. And thank God for that, and I hope He gives me force, gives me strength to see good on my expectations. If we look back, we see how much the court has achieved. The court has also been the object of criticism from outside. The court has been unloved. But we need to turn that to our advantage. We need to place it in our service. The court has its judges. The court has its state's parties, all of whom work and support the court. But there are many other stakeholders that bolster us in our work. There are the NGOs, there are universities and academics who have dedicated a large part of their life to supporting the court, thinking and working with the court and helping it to overcome the difficulties it faces. Now, I must admit that I have been a little bit disappointed. I haven't heard the word of the Office of Public Counsel for Victims since this morning. Let's not forget that we have an office which was set up, created by the judges to support the victims day in and day out. My office, the office which I head, and I'm Xavier Jean Keita, and I am the lead counsel at the Public Office for Victims, and I work hand in hand with Paulina Masida. My office was set up to bring about a balance where there had been a natural imbalance between the Office of the Prosecutor and the suspects and accused persons that find themselves before the court. I'll get to my point now. What I would like to see done is that there be recognition for the work of the two offices, in fact, of the OPCV and the OPCT, which support the victims and support the defense, and that they find or develop into full maturity in due course. They had a short or a late start, if you like. Our independence is necessary. We need to defend it day in and day out. It was set out in the rules. Mr. Keita, the chair asks the speaker to wrap up. Now, when President Chile decided that the two offices should be present and represented at various events, such as the giving of solemn declarations and what have you, those official and formal occasions over the last 20 years. We are also involved when the election rounds come around every 3, 6, 9 years. I believe that as our offices mature, they need to be recognized and not questioned. Their raison d'etre should not be questioned. We, of course, constantly review our work. We have our shortcomings, undoubtedly, but we push forward and aspire to fully fulfill our remit and not to be waylaid and distracted by little internal quarrels and conflicts and what have you.
You do have to interrupt.
I will have my last word, Mrs. Chair. Je voudrais dire enfin et pour...
And so finally, to end on a more positive note, perhaps. You referred to being stubborn, but positive. I myself consider myself to be both stubborn and an optimist. The day may be long, but it will come. It is a proverb that I bear in mind. And so, having completed the first 20 years, I think that we need to stand by what we have done, what has been positive, and to look forward to, with optimism, to more.
Thank you very much, Mr. Keita. I see a question. Is that Julie Fraser? You have the floor.
Thank you, Chair, for the floor. Thank you, Matthias. I'm very pleased to be here for the celebrations of the 20 years of the International Criminal Court. My name is Julie Fraser. I'm an Australian lawyer and also an assistant professor at Utrecht University at the Netherlands Institute of Human Rights. My question actually is sort of to all of the panelists, depending on how you want to address it, but it was triggered by something that Judge Pangalanga said about the civil law and the common law systems that influence the International Criminal Court and the systems of law that influence and inform its practices. And Judge, you know that I've written on the topic of Islamic law and encouraged the court to also look at other systems of law from around the world and how that might also inform their practice. So Judge, I wondered what your views are on expanding these systems of law that influence how the court operates to other systems of law beyond civil and common law systems. And I wonder how that also might influence, Mr. Registrar, your work that you do in terms of getting cooperation and whether recourse to other sorts of normative systems or national legal systems might help in your work. And then I'm also thinking about victims and how perhaps victims can be seen to be having justice also framed within their own cultural perspective, which for many cases includes also victims from Muslim communities across various different states and situations that the court is now dealing with. Thank you very much for your time.
I will just check if there are any other questions before inviting the panelists to respond. Do we have any other questions? I see a hand there at the back. Could you identify yourself once you've received the mic?
Good afternoon. My name is Alexandra Drik, Center for Civil Liberties, Ukraine. I have a question that relates to the issue of reparations. It's true that in the present circumstances, Ukraine has submitted an appeal to the International Court of the UN International Court, asking for reparations and having the investigation on Ukraine ongoing in the International Criminal Court. My question is, what exactly needs to be done on the investigation stage for the victims to receive reparations when the court considers the case? Thank you.
Thank you very much. Do we have any other questions at this time? I see a hand here. Is that Dove Jacob?
Thank you. I was told during the break that I did not introduce myself this morning, so I'm Dov Jacobs, Counsel at the ICC and Vice President of the ICBA. Although neither of those institutions will want to be associated with my question, so I'll just forget what I just said. It's a comment for, again, all the panelists, but it could also be for the panelists this morning. And Carla asked the right question, I think. It's what do we mean by justice? And I think it raises the issue of what do we mean by justice generally at the ICC. You know, the question procedural justice, as the judge said, the justice for victims, the question of the rights of defense. And I think it's very important to pick up on that issue and have an honest conversation about what justice do we want at the ICC as a criminal court. And I think that's an issue that was raised by the two presentations on victim participation and reparations, is that someone mentioned this morning that the key in French, you say, le nerf de la guerre, c'est l'argent. You know, if we had more money, we could do everything, but we don't. So there's always balancing of budget. And the question is, what do we want this court to do? And at some point, if you have, it was mentioned in the presentation on Trust Fund for Victims, that we should have more situations with more cases so that the Trust Fund can do more. But if you have more situations with more cases so the Trust Fund can do more, is the budget going to increase that we actually can have trials, fair trials, in parallel? And I use the word in parallel, and it makes me shiver, because it shouldn't be in parallel. That is the heart of the work of the ICC, which is to have trials. And then it can have an impact on the victims, etc. And I've always wondered, and I know I've had this conversation with Carla in the past before, is that I genuinely wonder if when we pushed for victim participation and reparations at the ICC, it was a great victory, it was a great change, nobody can deny that. But in some way, the NGO community did not shoot itself in the foot, because now states can just say, go to the ICC. We heard this morning that the hope of thousands of victims, millions of victims has been raised. But even if we have a perfect ICC, will that hope ever be satisfied? And states can say, we go to the ICC, and in alternative methods, local methods, truth commissions, reparation systems, cooperation with local communities, which might achieve some of the things we expect the Trust Fund to achieve, the ICC to achieve, might be better achieved domestically. And so we're making the worst of both worlds. We're not satisfying the thirst for justice for victims, and we're not giving the means to the court to actually do what its core function is to hold fair trials. So nobody's satisfied ultimately. Thank you.
Thank you very much. I'm going to pause here and bring it back to the panelists. Perhaps, Judge, you may wish to begin.
Thank you, Madam Chair, and thank you, Julie, for that wonderful question. Well, guilty as charged, yes, I limited myself just to the two most traditional approaches to law and to trials, the continental and the common law systems. And I do acknowledge that there are many other traditions out there that can be incorporated both in the sources of law of the court and both the substantive and the procedural practices of the court. And I do acknowledge we need to sensitize the court to these other sensibilities. But let me just identify some, questions. First of all, for complementarity, I've actually encountered an argument that the defense saying, well, there's a complementarity issue here because, look, we do have tribal systems of justice that we are fulfilling here. And so, I do acknowledge that there are other systems, but I also want to identify and anticipate possible issues that can arise along the way. And just by way of closing on this point, the very important point about the place of victims in the law and procedure of the court. You see, whether civil law or common law, you will have problems having the voice and presence of the victims that we provide for under the Rome Statute. In other words, if one relies on the old traditions, then we will have to make adjustments so that we can take fully into account the voice of the victims. Thank you.
Thank you very much. Minu or Carla, I don't know if either of you want to jump in on that question.
I don't want to, because I think Judge responded it thoroughly. Y voy a hablar en...
And I'm going to be speaking in Spanish, and my apologies for that. I'm going to take advantage of the system like others have done, and in order to broaden the number of languages that we use in an international court like this one. Having said that, I would like to say two things. First of all, we cannot talk about the victims of the fund without speaking about how the court and the fund are a single thing. They are one thing. They are one same entity, and we work together. And if there is something that I have been able to see and be a witness of during these 2 years that I have been part of the fund, it is precisely that, and I would like to thank you for it. That is to say, the cooperation and collaboration with the Registrar's Office. And without that cooperation, without that unity, that basic unity and collaboration and cooperation that we have been built, and I hope we will continue to do so, it wouldn't be possible to implement and do the work that we need to take care of. And then there is another thing I wanted to mention. It's a very general issue, but it emanates from the two panels today that have spoken to us today. Humanity is based on injustice. Humanity comes from injustice. There is injustice all around us. It is a reality. All the institutions like this one, they have to orient this unjust humanity towards justice, show us the way. In these panels today, we have asked ourselves a lot of questions, basic questions. Like Professor Robinson this morning, he asked a very interesting question about the permanent lack of satisfaction in the midst of our work. Everything that we do and everything that any court does throughout the world, in addition to this one that is so innovative. And then Professor Carla was also telling us about the sensibilities and the awareness that has to guide our activities, because we have to be able to reply and respond to questions and queries that perhaps don't have an easy answer, because these are answers that we have to build, we have to develop on the basis of our work, our actions, our capacity and willingness to respond, to find a solution. Because we are actors, responsible actors in the midst of this important structure for humanity that we are developing. So all of these questions this morning and now show us that we need a balance. We need to balance the situation. And I would call upon all of us who are present here today, let's not allow for a lack of balance to sneak in, because in other words, we get used to it and we say, well, they always accuse us of everything. And we come to the conclusion then that it won't be able to respond to those who really need a reply by our part because they've been hit, they've been affected, they've been hurt. So I would like to believe that this court, as justice, serves, as a great Uruguayan writer said, as Felipe Michelini. He said, what is the horizon for? Because we never achieve it. We never get there because it makes us walk there. Thank you very much.
Thank you very much. Carla, I think you want to add.
Thank you. I think these were all very interesting questions. Just to follow up on Julie's point, I think both the statute and the rules, certainly with respect to what does reparations mean, what are the possible assistance projects of the trust funds, I think there's good scope for going beyond the confines of civil and common law with respect to both reparations and assistance. What's most important is meaningful, and of course there's certain frames within which reparations is understood, but those frames are very broad. So I think there's great scope there, and I think that would be really helpful actually to further develop that. With respect to the question from Ukraine on what needs to be done from an investigation purpose with respect to the ability to receive reparations, my own view here is firstly the role of the ICC is but one of a number of different actors in relation to Ukraine, but also secondly, it's important to think about freezing assets. That I think is the most concrete thing that can be done at this stage to set the stage for reparations and assistance projects. So that might be something which requires clear strategic thinking. And then third point, with respect to the comments by Dov Jacobs, what does justice mean? And to what extent does the reparations framework within the ICC shoot itself in the foot by ignoring or making it easier for states to put that task to the ICC. I think if we look at the practice, though, of the cases that have come before the ICC so far, the idea that if the ICC had held back and not done anything, that somehow these countries would have stepped up, I think that's just not correct in relation to the cases that have come before the court just yet. Maybe it'll be correct in future, but I don't think it is currently correct. I think the way in which to explore further synergies is through the complementarity process as well as through state cooperation. And I don't think that's been explored other than in a very narrow way. I think there's much more to look at with respect to how reparations and assistance to victims fits within notions of complementarity and notions of state cooperation. And that would be an area to look at. So hopefully before the next reunion, we'll have more to say on that.
Thank you very much, Carla. There was, I think, was there any question from the audience? I believe there may have been one question. Registrar, Jennifer, in the meantime, if there is any issue that you want to come in on, you still have about 2 minutes or so.
Thank you, Lori.
I would like to seize this opportunity to talk about the mix of cultures. There was the issue of civil law and common law. And today, I think in the ICC, we have an autonomous practice. I think it is already a real heritage. There is a system that has been created, and it is jurisprudence. That is why we also encourage Counsel to follow the information and publications of the ICC to know about this process. So this hybrid process is now quite independent. The second part is the place of culture, the role of culture. So I talked about the importance of adapting the culture before the courtroom, because we are talking about testimonies before joint teams, whether which are diverse in the OTP, in the defense teams, and so on. And the judges are able to ascertain justice. So we have also talked about site visits, which are important, so that the judges should be able to know better the situations they are dealing with. Thank you.
Registrar, you have the last word.
Well, it's just a reflection, really. And it goes back to your introduction, a long time ago, actually, now, under the presidency of Judge Kirsch and with Sylvia as my boss. We were negotiating the rules of procedure and evidence at the PrepCom. And at the time, it seemed such a difficult thing to do, to bring these two systems together. But as Philippe, I think, rightly said, we achieved the rules of procedure and evidence with all their flaws based on consensus. But I think one of the triumphs of the court over the last 20 years is, I think Jennifer's right. I think we've arrived at our own system, and that there is now a convergence, I think, on the jurisprudence of the court. I look at James, we talked about this often, James Stewart, sorry. What is coming together is an institution with its own rules, its own jurisprudence, increasingly its own practice directions that everybody's following. And I think if you talk about what we've achieved in 20 years to build a new institution, I think that is one of the most powerful things that has happened. I was a common law lawyer all my life. I don't feel I'm a common law defender of the common law in the court. It's a new jurisdiction, but that's a triumph, I think, of the last 20 years. Thank you very much.
Thank you very much. I think that is all, and we are about 4 minutes over the time, but I believe that we have managed to address some of the key issues that we wanted to cover in this session. So that leaves me only to say thank you to our panelists. Judge Pangalanga, thank you very much. I know I will hand over to the moderator, Sonia, but I wanted to personally say thank you to all the panelists for respecting the time and for sharing your insight, and also to acknowledge Monsieur Jean-Pierre, Monsieur Keita, and Madame Paulina Masida. You mentioned that you were not mentioned at all in the comments, but I can say to you that you were not forgotten. Thank you very much.
Thanks to you also, Lorraine, for chairing this panel. And for the audience, it's now time for a short break. We'll be back in about half an hour.